meeting to order. At this time, I'm going to ask Mr. Terry if he would lead us in a word of prayer, if you would stand with us. Amen. You may be seated. At this time, I'm going to ask Mr. Dewey if he would do our roll call since the secretary, Ms. Sharon, is not present. Mr. Dewey.
Mr. Corbin Edens. Richard Ricky Burnett.
Present.
Ms. Sharon Hunt. Mr. Joe Gooseby. Mr. Harold Smith.
Here.
Miss Pam Hunt. Mr. Ted Woodell. Miss Wendy Moore.
Here.
Mr. Carrington Lockley.
Here.
Mr. Larry Chavis. Mr. Richard Jones.
Here.
Mr. Reginald Oxendine. Dewey McNeil here. Dr. Marshall Locklear. Mr. Terry Hunt.
Here.
Mr. Shelley Strickland.
Here.
There's only 10.
Meeting starts at 6:30 when we do the roll call in order for us to progress and go ahead and take care of the business. You know where she's at? Say what?
I said we've had this issue numerous times before, and we have been a little lenient to wait for someone to get here because we've had issues before that you needed one vote, and we've had people call people to come. So I would beg the speaker's leniency on this one.
Miss Belinda, do me a favor. Could you text her back and see exactly where? Okay. If you bear with us. She's out in the parking lot. She'll be right in. We'll give her about 5 minutes.
Mr. Speaker, I'd like to recognize Dr. Marshall Locklear.
Thank you. At this time, as we further proceed, we have before us tonight a petition for recusal of Chief Justice Joshua Malcolm in ethical and unconstitutional actions by the Tribal Supreme Court. And this is from Mr. Ron Oxendine. Mr. Oxendine, at this time, I will give way to you to address the Ethics Committee, sir.
Okay, thank you very much. Can everybody hear me?
Yes.
Good, okay, thank you. Again, thank you for the opportunity to address the Ethics Committee here this evening. I'd like to start by just asking a simple question of the members of the Ethics Committee, and that is, has everyone had the opportunity to see the actual trial, if you will, the playback of the video from the hearing that was held with regard to Locklear versus Oxendine? Can I see a show of hands if that's okay? Great, thank you. In addition to that, there's also documents that came along with that particular video. And again, another question, has everybody had a chance to look at those documents that were presented at that hearing? Okay, thank you. One of the things that I intend to do is I intend to basically tell you a story. I've always tried to use that approach when I give presentations throughout my career. And I always want to try to make sure that it is very simple, very clear, and very concise so that you can understand what I'm trying to convey to you, whether a committee or an individual. And tonight, as we talked about, we want to talk about ethical issues and conflicts of interest regarding the Locklear versus Oxendine case. So some of our objectives are just a few. Ultimately, the Locklear versus Oxendine case removed my name from the ballot for tribal chairman. And the part that we're going to talk about tonight wants to talk to you and convey to you all the issues that were associated with that hearing. And you're going to hear some ethical issues and conflicts of interest that should have been addressed as part of that hearing. So I want to make sure that we're trying to make it clear to everyone what occurred. So I like to start by, again, just going back to my story. And my story starts on the 22nd of September, 2020. Now, probably, I will say most of you already know what 22 September 2020 was. And that was the date I was released by the LTE board working with LTE. But that's not what I want to talk about. It's just a starting point of the story. On the 6th of October, the Tribal Council received a brief from Lumbee Tribe Holdings as part of their annual shareholders brief. After a week or so, and that occurred on the 6th of October, and after a week or so, a number of tribal council members at that time asked, had I seen the presentation, and number two, would I conduct a review of that presentation, which I did. For those of you that were on the council at that time, you received a document from me that I, along with the chairman, that identified 27 issues that were wrong about that presentation. Now that's a very important part. 27 issues wrong with that presentation. But I now want to read as part of one of the documents that's part of the Locklear Oxendine case, and I'll call it case. And it's an affidavit that's submitted by Joanne Hayes. And it goes through the normal parts of she's 18 years and older. She has personal knowledge of Ron Oxendine. But I'll start with number 3 and just read the key comments. My knowledge of Mr. Oxendine's principal place of residence is based on the following. I had several conversations with Tina and Ron Oxendine beginning September 2020. I also visited with Patsy and Mark Locklear and saw his car at this residence on numerous occasions. Additionally, while employed with LTE, Joshua Malcolm, General Counsel for LTE, asked me to send the document to Mr. Oxendine in Virginia in October 2020 concerning a cease and desist responding to a document Mr. Oxendine had sent to the council. That's the document I just mentioned. I informed Mr. Malcolm that Mr. Oxendine was in the process of moving to Prospect and would not be back in Virginia for a couple of weeks at least. After mailing the document to Virginia, Mr. Malcolm asked me daily if we had a receipt for Mr. Oxendine accepting the letter. I informed him each time that Mr. Oxendine was in Prospect at his mother-in-law's house, residing with her because of his mother-in-law's health condition. I declare under penalty of perjury that the foregoing is true and correct. This the 13th day of October 2021, signed by Joanne Hayes and notarized by Belinda Hunt. The key point I want to make about that is Chief Justice Malcolm knew in October 2020 that I had moved to North Carolina. And he also knew that I was residing at my mother-in-law's home, where I reside today. So let's think about the clock. You know, that's been over a year. I actually arrived on the 26th of September of 2020 at my mother-in-law's house. Why? As I've stated before, I didn't have a job. And I had the free will, free ability to go wherever I needed to do because I was not tied down in Virginia. So we moved home to North Carolina, where again I've been ever since. In addition to that affidavit, during the Locklear versus Oxendine case, there were 11 other affidavits submitted by people that had contact with me, my wife, a family relative, of course, but other people in the Prospect community and in Virginia and in South Carolina, people that have known me for many years, that I had moved to North Carolina to take care of my mother-in-law. While you're there, you obviously, because we're moving, one of the things that came out is that we had planned, my wife and I, to move to North Carolina long-term as part of retirement. In other words, after my career, it was time to get back to my roots, come back home, and live out the rest of my life enjoying family, enjoying the area, and enjoying the relationship with other Lumbees. In other words, a Lumbee came home. Things continued to go well until in the middle of my campaign, I received information that LTE had lost the contract on the 26th of July of 2021. So I put out a video indicating how that would impact the Lumbee tribe's 8A program. Because in 27 years of my being a defense contractor, I've never had that happen. So once I was gone from supporting Lumbee Tribe Enterprises, there were problems that developed. So one of the things that occurred when we had Locklear versus Oxendine, one of the first things that was asked was if anybody has any issues related to the proceedings of the hearing or the case. So my lawyer, Mr. Tippett, stood up and made a motion for disqualification and or recusal of Chief Justice Joshua D. Malcolm. And if you see the video, you'll see all this occurred. Now, the key thing about that is the Chief Justice would not allow the document I'm holding to be presented as part of the trial. And the reason for that, in my opinion, is you don't want to have this document as part of the document because it points to a lot of irregularities associated with the trial. So I want to read a few of those and talk to you about some of the issues. One of the things that you also, before I do that, one of the things that is key is that, again, on the 30th of July, Lumbee Tribe Enterprise sued me for making that video. So I spent the next 2.5 months in court trying to defend the political video. Now, I'll also tell you as part, and I'll read it, but again, there are some issues there. And let me just begin reading components of this document. The tribal chairman has significant influence over who serves in leadership of LTE and LTH. Members of LTE's leadership team risk losing their jobs if Oxendine succeeds in his bid for chairman. On 30 July 2021, LTE filed a complaint against Oxendine in Robeson County. LTE alleged that Oxendine denigrated and criticized LTE leadership and policies during his campaign for tribal chairman. The Honorable Jason C. Disbrow, Superior Court Judge, concluded in an order that LTE's claims against Oxendine were motivated by LTE's leadership's interest in preserving their jobs and authority. Now, let me read that again. That LTE claims against Oxendine were motivated by LTE's leadership's interest in preserving their jobs and authority. Again, LTE's leadership includes Chief Justice Malcolm. The Tribal Council is vested with the authority to adopt an ordinance prescribing conflicts of interest in the performance of duties by elected and appointed tribal officials, which the ordinance shall require a tribal official to recuse him or herself from any decision or vote affecting his or her pecuniary interest or a family member. I had to look up that word pecuniary. It basically talks about the interest of money. How will money affect that decision? Lumbee Supreme Court justices are appointed by the Tribal Council. I should say they're appointed and recommended by the chairman and then endorsed and appointed by the council. Therefore, Lumbee Supreme Court justices are subject to the ordinance prescribing conflicts of interest. Appointees are prohibited from using their office to further private or personal interest by seeking to influence a decision that is made by another person. Judges are prohibited from ruling in any case where she/he has any direct interest. Again, what does that mean? That means based on if Ron Oxendine became the chairman and the chairman has influence over LTE and LTH, not to make all decisions, but influence, that would directly impact Chief Justice Malcolm's job at LTE. That right there is a conflict of interest. As Chief Justice Malcolm is the General Counsel for LTE and President of LTH, he has a direct and personal interest in protecting LTE, as to do so protects his job and income. Furthermore, based on the order attached hereto in LTE's Superior Court litigation against Oxendine, Chief Justice Malcolm has a specific interest in preventing Oxendine from becoming tribal chairman. Now, this document, again, is from the Robeson County Superior Court. It's not in the tribe, it's in the public, and was handled in public legal scenario or situation. It's not within the tribe. Chief Justice Malcolm cannot rule impartially on this issue. His interests relative to his position as LTE's General Counsel would be directly furthered if the court ruled against Oxendine and in favor of petitioner David Locklear. That should start to begin to give you a storyline of what could happen if I became the chairman with regard to Chief Justice Malcolm. So we submit our request for recusal. He declined, did not allow this document I just read to be entered into the court documents, but it set a precedence, if you will, that there are conflict of interest issues related to Locklear and Oxendine hearing. Chief Justice Malcolm indicated he had a letter from the state bar addressing his ability to handle the Locklear versus Oxendine case with regard to conflict of interest. I could not find this letter in the Supreme Court documents on the website. This letter or document needs to be provided to the Ethics Committee in the next 24 hours and included as part of the court documents. Now, I will tell you, I've talked to other lawyers, and I've been informed that the bar does not write letters to handle conflicts of interest, as Chief Justice Malcolm indicated. I would love to see that letter provided by him and included as part of the court documents. But I also wanted to talk about I want to now go to the Ethics and Conflict of Interest Ordinance. Now, if it's okay with you, Mr. Speaker and Chairman of the Ordinance Committee, I'm going to reference the March 12, 2010 document, although I know that there was an amendment in October 21 of 2021. But the points I'm going to make in the 10 version have not been changed in the 2021. But the reason I want to use this one is because of the dates associated with the amendment of October 21, which was after 14 October when our case, the Locklear-Oxendine case, was held. Whereas the council has determined that the Ethics and Conflict of Interest Ordinance shall guide the actions of all persons who has a relationship with the tribal government. Being enacted by the Tribal Council of the Lumbee Tribe of North Carolina, the following ordinance that shall be cited as Ethics and Conflict of Interest. Section 1, Ethics and Performance of Duty. Line 1 says the tribal chairperson, council member, officer, appointee, employee, or any person or entity that provides contractual service. And it begins to go through the ethics requirements for those individuals. And I want to make a point. The chief justices and the justices on the Supreme Court are appointed. That's the key point I want to make there. Section 2, Conflict of Interest in Performance of Duty. A person as identified in Section 1 must not exercise an official power or perform an official duty or function if the person has a conflict of interest or an apparent conflict of interest. I go to line number 6 under paragraph 2. A judge shall not be qualified to act as such in any case where she/he has any direct interest. Now, I spoke to you a little earlier and indicated that if Ron Oxendine is elected chairman, it could have an impact on Chief Justice Malcolm's income and his job. So that paragraph is very significant. A judge shall not be qualified to act as such in any case where she/he has any direct interest. And there's more related to relatives. As I continue in section 6, it talks about sanctions. Any person identified in Section 1, including appointees, found guilty of violating this ordinance, and then it proceeds to give you the 3 sanctions that can be levied. But I only want to talk about number B and C. To prohibit the person from holding any further committee or assignments of office or authority. C, to remove the person from any position or office held in accordance with the Constitution and any ordinances on removal of members. So what is a conflict of interest? Definitions. Conflict of interest reads, a member has a conflict of interest when the member exercises an official power or performs an official duty or function in the execution of his or her office, and at the same time knows that in the performance of the duty or function or in the exercise of the power, there is the opportunity to further his or private and or personal interest. So while Locklear and Oxendine Locklear versus Oxendine was advertised about keeping me and getting my name removed from the ballot, there are personal interest concerns that are addressed in this ordinance that is clearly shows that Chief Justice Malcolm should have recused himself and not participated. And I hope you're following along, because it's very key that you understand this. So another definition, ethics, the last thing. In this context is that contained in Black's Law Dictionary, the definition of ethics is professionally right or benefiting, conforming to professional standards of conduct. Well, I can assure you that as I read these documents and I read the Ethics and Conflict of Interest Ordinance, there is a clear issue with Chief Justice Malcolm having served as part of the court. Regardless of what the court decided and how it impacted the result of the case, he should have recused himself and not participated. And I think that is a severe violation. I would recommend that as the Ethics Committee and eventually the Tribal Council, that you impeach, and I'll use that word, impeach. He needs to come off because he made a major infraction against our Constitution and against our ordinance for ethics and conflict of interest. This committee has that responsibility, and it is your responsibility to take that under consideration and take action to remove Chief Justice Malcolm from the Supreme Court and apply the sanctions identified in the paragraphs that I read contained in the ordinance. That's the message that I wanted to convey to you this evening with regard to conflicts of interest. Now, at 2:30 this afternoon, I received an email, Mr. Burnett, of a document that was emailed to you, and it's a letter dated 19 November 2021. And it was from the Supreme Court of the Lumbee Tribe of North Carolina. Do you recall that you received that email or document?
Yes, sir.
I just want to read a couple of, really, I don't even really need to read the whole thing, of course, but I'll paraphrase. And it says, the last paragraph, accordingly, the court, just as it did in 2019, and I have no idea what they did in 2019, hereby declines to subject itself to the jurisdiction of the Ethics Committee and or the Council regarding these matters or any related matter. That is, again, is in direct violation of the Ethics and Conflict of Interest Ordinance. I don't know where you guys come from. I don't know what your background is, but I'm a military guy, and I served my country, offering up my life to go fight countries that was not in line with our democratic policies. What that statement tells me, and should tell you, Mr. Speaker, that the Supreme Court is a dictatorship. Now, I don't know what you guys know about the history of the United States, but we don't like dictatorships, and we apply our resources to prevent them, to get rid of them. That is the United States way. And we are, even though we're the Lumbee tribe of North Carolina, we are part of the United States of America. And when you have a Supreme Court telling you that they don't care what this committee or the tribal council says, you know what? It's time that you tribal council members and committee members, you need to take action. You need to impeach all 4 of the Superior or Supreme Court justices and start over. Because the ones you have now, based on the documents that I've read, clearly are violating our Constitution. They are not representing the Lumbee tribal members. And in my opinion, as we all like to talk about, if you don't believe Washington, D.C. and the rest of North Carolina is not watching and knows about Locklear and Oxendine, you better wake up, because they do. But I challenge you, and why I came here tonight, you need to take action. You cannot have a rogue Supreme Court doing what they think and using the Constitution where it benefits them and not using the Constitution if it benefits them. And folks, that's what this letter says, Mr. Speaker. And you, representing our people, have to take action to resolve this issue. And that is my challenge to you tonight. So I want to thank you for that time. But there's also the second part. And you see Mr. Wilfred Clark sitting here next to me. He is going to represent and talk about the actual order that the Supreme Court published resulting from Locklear and Oxendine. And we're going to talk about those ethics and conflicts of interest that he will brief you on. He's a lot more astute at the details. He and I have conferred, so although not my lawyer, he is my representative as if he is my lawyer tonight. So I will let Mr. Clark begin to address the order.
Thank you.
Mr. Gerald?
Yes.
Can you hear me now?
Yes, loud and clear.
Yes. It is my understanding, and I just want to make sure I'm clear on what you're seeking tonight. It's an ethics complaint against Supreme Court justice, a Supreme Court justice.
Well, I think you should go ahead.
According to the documents that I received and according to the agenda,
yes,
if we're here tonight because of that one reason.
Correct.
That one particular judge.
Yes, related to the Supreme Court.
My question is, Mr. Speaker, going forward, I mean, I think you've done and shared everything it is that you have a complaint with as far as this particular justice. I don't think the trial itself is on the agenda tonight, or any outcome or ethical issue as it relates to it. Anything pertinent to this judge that is being complained, I'd be glad to hear. Anything other than that, I don't think is relevant to what we're here for.
Well, I disagree with your comment. Appreciate it. But in paragraph C, The Supreme Court violated the authority, and I'm reading for what the letter that was submitted to the Ethics Committee. They violated the authority of the Board of Elections to promulgate the tribal elections in accordance with the BOE policy. The BOE has statutory authority to certify the eligibility of candidates. This further does not conform with the preamble of the Constitution of the Lumbee Tribe of North Carolina. The Supreme Court acted in violation of Article 9, Section 1 of the Constitution. The Board of Elections decided to extend the election date to 14 December. The Supreme Court subsequently told the BOE that they would and are mandated to conduct the election on 9 November 2021, which is a violation of the principle of the separation of powers in the Constitution. Because those actions resulted in the order, I respectfully disagree with you, Mr. Gooseby. Mr. Clark. This one.
Thank you. Mr. Burnett, Mr. Chairperson of the Ethics Committee, we're here tonight because of that. The 16-page fairy tale from the Supreme Court. We should not be here tonight. We should not be. This case should not have been heard. It should not have been heard because it was heard in violation of our rule of law, established law. Do you have, or can I get this to you so that you can, this particular document that I want you to see?
Did you not send that to us, Mr. Oxendine? Is that the same one?
Yes.
Everybody should already have that, I'm pretty sure. What, can you read from the top of it, Mr.
Yes,
Welford?
this is, excuse me, sir, I'm sorry.
No, I was saying if we don't, but I think we've got received all the dockets.
Did you get it?
No, I didn't really send any documents as part of this other than the letter.
Okay. Let Miss Belinda check it out. She'll know for sure whether we got that or not. And if not, then we can get copies if you don't mind. She'll get you a copy, Mr. Welford. Go ahead.
Well, I'll come back to that, but I was hoping that we could look at that, and if we looked at that, we could go ahead and get on out of here and be gone, because we shouldn't be here. But I'll just continue on, and when she brings that back, we'll go. Let me say this to you. Thank you for hearing us. Just going to ask you to be fair and impartial. That's your duty, and your oath requires that. Whether you like me or not, just listen and await evidence I'm going to present to you. I ask you also to put aside your personal feelings for Ron Oxendine. This is not about protecting your candidate of choice, nor punishing his or her opponent. Let me say this to you, I am not now, nor was I ever a member of Ron Oxendine's campaign staff. I had never seen or met him until Tuesday night, October the 26th. I recognized him then by the pictures I had seen on his campaign signs scattered throughout the tribal territory. I have never spoken to a member of the Supreme Court that I can remember. If I did, I didn't know who they were. I couldn't pick either of their faces out of a police lineup tonight. I don't have an axe to grind with either of them. What I know of them, I've learned from reading their 16-page Locklear v. Oxendine ruling. I've learned that they're very talented and skillful in the way they write things. They have masterfully prevented Mr. Oxendine at least 6 times from making known the unlawful, unconstitutional, unethical deeds they have done to him. All I know about them, I learned from their writing, and what they have done, I believe, would get them all disbarred if it had been done in the Robeson County Courthouse. Both them and also Mr. Locklear's counsel, Gary L. Locklear. Thank you again for hearing us. In our quest for justice, you're the first committee, a court board, to give Mr. Oxendine an opportunity to address the obvious violations of the Constitution, tribal ordinance, Lumbee custom, and federal common law that the Supreme Court has committed. Violations that were purposeful and in violations of the oath they took when they were appointed justices, thus constituting a breach of good ethical conduct. Violations that we will prove by the preponderance of evidence that we're going to present to you. If you read that 16-page document, the preponderance of evidence is the standard that the Supreme Court established in the first paragraph on page 8 in its ruling, Locklear v. Oxendine. And that's the case that brought us here tonight, the preponderance of evidence. At Piney Grove School in about 1955, I learned a lifelong lesson from Mr. Vincent Lowry in our math class. It was called his function, the least common denominator. In that process, we take a large number and we reduce it down to its simplest terms. That process came to my mind when I read the Supreme Court's ruling in the case that has us all here tonight, where I suspect none of us wants to be. This ruling is 16 pages long. That's the large number. At the top is what we must reduce down to see what it makes it necessary for us to be here. But here's not a number, but it's a pre-planned, carefully orchestrated process, and it's called Get Ron Oxendine's Name Off the Ballot for the November 9 tribal election. That process began with the definition of one word, and that word is promulgate. From May 4th of 2005, that's the date of Tribal Ordinance 2005-002. That's the election ordinance. To that date, it was signed into law until October the 20th of 2021. The Tribal Council used that word promulgate to mean to create, to make, and to establish tribal regulations to conduct tribal elections. Article 10 of the Constitution uses the same definition of the word promulgate to mean to create, to make, and to establish necessary regulations under the authority of this Constitution and tribal ordinance governing voter registration and conduct of all regular and special elections. That is the definition of the word promulgate in Tribal Ordinance 2005-002, enacted into law May 4th, 2005. In Section 3, Paragraph 2, it reads, the election board's authority to promulgate rules and regulations shall include, it's important, but not limited to. Their first duty in Section 3 of that ordinance in paragraph number 1 reads this. Verifying that persons meet the qualifications for candidacy under Article 2 of the Constitution and any tribal ordinance. Paragraph 2 goes on to read, certifying candidates. That's the duty and the authority granted to them by the Tribal Council. The Board of Elections did their duty under the statutory authority that was given to them in that election ordinance. If you read that ordinance, the beginning to whereas was written by the Tribal Council. Section 1 was written by the Tribal Council. Section 2 was written by the Tribal Council. Section 3, the Tribal Council directed the election boards to write. Section 4, the Tribal Council wrote. Section 5, the Tribal Council wrote. Section 6, the Tribal Council wrote. Section 7, the Tribal Council wrote. Section 8, the Tribal Council wrote. And under Article 8, Paragraph 2, of the Constitution requires a candidate to be 35 years old. Mr. Oxendine met that requirement. Article 8, 2B also reads, and he has maintained his or her principal place of residence in the territory of the tribe for the preceding 1 year. Mr. Oxendine met that requirement, and we're going to prove that conclusively with the help of the Supreme Court's own words contained in their 16-page ruling in this document right here that they produced on that case. How do we know, and here's the question, how do we know that the Board of Education definition is correct and the definition of the Supreme Court is wrong? How do we know that? Their wrong definition is written in the third paragraph from the bottom of page 6 in their ruling. It says, and this is what it says, it says, we believe the word promulgate. You can believe about anything you want to. We believe the word promulgate as used in Article 10, Section 1, subsection A of the Constitution means to carry out and to put in effect rules and regulations previously legislated by the tribal council. They're just as wrong as two left feet. That's not the position that the tribal council has held since May 4th, 2005. In May 4th, 2005, they defined the word promulgate to mean to make, to create, and to establish. How do we know that? How do we know? It's clear as night and day. The election ordinance was enacted into law in May 4th of 2005. The tribal council did not pass another ordinance or establish any other guidelines for the BOE to rely on to put into effect, as the court wrongly says. In 2006, 2005 is the ordinance. In 2006, tribal elections were held. The tribal council did not enact another ordinance nor establish any other guidelines for the BOE to carry out or put in place, right? Any election challenges would have been done so according to that 2005 ordinance and the guidelines promulgated, created, made, and established by the Board of Elections according to its oath and duties in Section 3 of the ordinance. 2005, they said create him. You do it. The court says, not put in place something. Well, in 2006, the tribal council didn't put in things for them to rely on. The same process was followed for tribal elections in 2007, 2008, 2009, 2010, 2011, 2012, 2013, 2014, 2015, and 2016. Any election challenges up through 2016 would have been handled in accordance with the 2005 ordinance and the guidelines created by the Board of Election. 12 years. On July the 5th, 2017, the tribal council passed and the tribal chairman signed into the law an amendment to that election order that had been in the law since May 4th of 2005. The amendments they made did not change the meaning of the word promulgate that the tribal council established. In fact, it affirmed what the tribal council said in that vision. How do we know that? Here's how we know that. Simple. An election was held in 2017 under the provisions of the amendment orders and the election guidelines created by the Board of Elections. Any challenges to the results or procedure of that election were resolved under provisions that the amended ordinance and the BO guidelines it had promulgated, made, created, and established in accordance with the amended election ordinance. That's 2017. Listen, The tribal council did not pass, nor was there another election ordinance signed into the law where the BOE, the Board of Elections, were given new rules to carry out or put in place according to the wrong definition unlawfully used by the Supreme Court, used in, Locklear v. Oxendine. The tribal council did not pass, nor was there any other election order amendments signed into law in 2018, 2019, nor 2020. Nor were there any new election guidelines put in place for the BOE to follow. Any challenges heard for tribal elections 2018, 2019, and 2020 would have been heard according to that amended ordinance on July the 20th, 2017, and according to the guidelines promulgated, made, created, established by the Board of Elections. Not one ruling, no, not one, ever called into question the elections created, made, and established by the Board of Elections in 2005. Not one time. Then comes now, right? Now we're talking about Lumbee custom, in case you don't know what I'm talking about. In the court over yonder in Robertson County, they call that precedent. We call it in our Constitution, we didn't use the word precedent, we used Lumbee custom. It's in there for a reason. I know because I helped write the thing. I know what it means. Then comes 2021, and the Supreme Court rules that the portion of law regarding Ron Oxendine's eligibility was unconstitutional. Why? Because the big number was get Ron Oxendine's name off the ballot in the November the 9th, 2021 tribal election. That's their goal. So ruling him ineligible because of his residency, they figured was the easiest way to do that. I know that because that's exactly what they did. Now, I can't read their mind, but I can read their writing. Their lawyering is better than mine, but my smelling is better than theirs. And what they smell is rotten. And it smells rotten because it is rotten. What they've done is a violation of their oath of office, an ethical violation of the highest magnitude. It cannot get any worse, my friends. An ethical violation cannot get any worse in our government than to rob of man of his rights written in the preamble of the Constitution, unethically violating his rights under the provision of the Constitution itself, unethically violating tribal ordinance, unethically violating Lumbee custom, and yes, even unethically misrepresenting federal common law. And we'll prove it all by a preponderance of the evidence, by their standards. So now, our first least common denominator to get Ron Oxendine's name of the ballot in the court's 16-page ruling was the word promulgate. And they were wrong. They were wrong. You created that word and put that word there. I say you, the tribal council, in 2005, and it's been that way for 16 years. We have relied on the guidelines written by the Board of Elections as directed and ordered by the tribal council. Now here's the second word and the least common denominator. And that word is intent. That's the second. There's four of these least common denominator words. The first one is promulgate. They were wrong on that. Willfully wrong. Unethically wrong. The second is intent. They used this word not one time, not two times, but they used it 6 times in its ruling to describe Ron Oxendine's state of mind regarding his residency. On page 8, they used it 3 times. They used it once on page 11, they used it once on page 13, and they used it once again on page 14. We can use that same word intent at least 16 times to describe actions or inactions of the tribal council. For 16 years, the tribal council never intended to write further election guidelines for the Board of Election to follow. From the first writing of tribal ordinance in 2005, it intended for the Board of Election to do that. It empowered them in 2005, and to this day has written no further rules or instructions. If the tribal council had intended to put in some other legislation for the Board of Elections to put in place and to rely on, surely it would have done so in the last 16 years. But they haven't done it in 16 years. It has not had any intentions to do so for 16 years. And I suspect, as I sit here right now, it is not on the agenda for the next Tribal Constitution and Ordinance Committee meeting to do that. It hasn't done it because it had no intentions to do it when they passed the election ordinance. They intended that the BOE in Section 3 of the election ordinance, they intended for the Board of Elections to do it. They gave them the authority to do it and told them it was their duty to do it. Read Section 3. And it was their decision, meaning the tribal council's decision, to do it that way. And the court can't change it, even though they think they can. No court for the last 16 years has questioned the election guidelines created by the Board of Elections. Every tribal council representative that has filed for a council seat in 16 years has done so according to that tribal ordinance in 2005-002 and amended on July the 20th, 2007. And they have filed on the election guidelines promulgated, created, established, made by the Board of Elections. Every candidate that has filed for tribal chairman in 16 years, and there's 6 of them, has done so according to that tribal ordinance in 2005 that was amended in 2007, and by the election guidelines the Board of Elections created. I can think of perhaps another word, and that word that courts like to use, that word is precedent. I know I can see Lumbee custom rule of law at work here. It has been our law and our Lumbee custom for 16 years to rely upon the guidelines promulgated, made, created by the Board of Elections. Not to rely on or to put in place like the Supreme Court said, right? Mark Brooks, Mary Beth Locklear, Joshua D. Malcolm, and Everett Moore, they can see that. They know it. They just don't want you to see it. They didn't figure anybody would see it. They didn't figure nobody would read this blessed thing. They didn't figure that. They need to be, now the word we use is impeach. Now our tribal conflict of ethics and conflict of interest ordinance, nor nowhere in any of our rules of law, in the Constitution, ordinances, Lumbee custom, or federal, do we use the word impeach. The word in our ordinance is removal. But at the end of it, Mr. Chairman, it's the same thing. Get the bums out. That's what I mean. Remove them from here. Get them out of here. And you need to do that today. Now, that was word number 2, and the least common denominator. I remember I've talked to several people. People tell me, Wilford, did you read that? That sounds so good. I said, yeah, that really sounds good. I said, it's like a fairy tale. That's how good it is. And at the end of the fairy tale, somebody lives happily ever after. At the end of this fairy tale, Malcolm and Brooks and Moore, they're going to live happily ever after. But to them, it's a fairy tale. To me and you and the 65,000 other Lumbee people, it's a horror story. Because they're relegating us to slaves. Back in the slave quarters. And we got to feed off the master's crumbs. That's what they're trying to do to us. Webster's Dictionary, we can go ahead now with the third least common denominator word, and that word is preponderance. That's the standard, again, that the Supreme Court used in making its ruling in Locklear v. Oxendine that has us here tonight. Read it. The standard is the preponderance of evidence. What is the preponderance? Webster's Dictionary, that's part of Lumbee custom. Had it all my life in school, didn't you? Want to know what the meaning of the word is? We didn't go to federal common law. We went to the dictionary. You can Google preponderance on your phone right now, your smartphone, and you get the same answer.
Mr. Clark, I'd ask you if you could go ahead and wrap it up because it's 7:30. Our time is like an hour, and then we are going back in closed session so that we can make a determination.
I can't do that. I can't do that. That's not sufficient time, and I respect you, Mr. Chairman. I respect you. I respect you. But the court spent all day creating this. We cannot unscramble it. We can't go through 16 pages on this fairy tale in this amount of time. Aldrich v. Lutheran Evangelical Good Samaritan Society, another 7-page document that they use, right? That is 23 pages. And it is filled and rife with violations of ethics. And to prove, we're talking about violating this man's constitutional rights by unethical behavior. This man has spent tens of thousands of dollars in campaigning and in literature and holding rallies all the time. And by unethical actions of a Supreme Court in violation of their oath of office, they have taken every bit of that. Mr. Chairman, I ask you, in all due respect, I ask you to not to shut me off, to let me conclude. Please let me conclude. If you have to take a recess, please let me do it. It's too important. It is too important. Let me say this, and this is part of my end, but I'll put it at the beginning. There's no question in the minds of anyone in this building or watching by Zoom, the tribal membership has lost confidence in our government. They're lost confidence. The ethics committee is the conscience of our government. The ethics committee is the do right. And if we can't trust the ethics committee to do right and to be fair and to be impartial, then who can we trust?
How much longer?
About an hour.
Mr. Speaker, if we could just stay to the point instead of going way over there in left field.
That's not left field.
Well, let me finish speaking what I'm saying. If we could stick to the point.
This is the point.
Let me finish speaking. If we could stick to the point, we could get it done instead of going, way over in left field. If we can keep it down to the point that you're trying to present to us, it would be so much better.
I haven't, and Mr. Hunt, I beg to differ with you. I have not been to left field. I started at home plate. I said there's four different components to this thing.
Point of order.
Mr. Oxendine.
Yeah, Mr. Welford, let me inject myself here. Mr. Welford is correct. I mean, you talk about how many hours do we spend during the day? 15, 16 hours when we did Locklear Oxendine? We're trying to compress this into an hour. And I agree with Mr. Welford. If we need to take a break and use the restroom, let's do so. But some of the key things that he just mentioned, which is the key case used by the Supreme Court, he's getting ready to address. And that is probably the most important part of the 4 words. So I would request that, again, if it takes another 45 minutes or whatever, I think we deserve that.
Okay.
For 16 times.
I'm sorry. Hold on. Mr. Richard.
I respect what you're saying. I respect what Mr. Terry's saying. But the words bums, I don't think is very respectful to anybody in here and on the Supreme Court.
Yeah.
And those are your words.
I didn't hear. I didn't understand what you said.
His statement was that you called them bums. And what I would ask, Mr. Weffer, as you're presenting.
I'll respectfully ask the Ethics Committee to excuse me and to forgive me for using that word bum.
Okay. Mm-hmm. Mr. Gerald? Turn it on.
Knowledge of stuff. You have everything written down that you're saying, or would it be nice if you just read it and not holler it out and not preach to me? I mean, I can hear you better when you're not hacking and, coming from the pulpit, so to speak. What you're saying is important.
Yeah.
I don't understand what
it
you're
is.
saying, and I can't understand it when you're hollering.
Yeah. Miss Wendy?
Respectfully, to this body called the Ethics Committee, we are here in order to hear a tribal member's concerns of the violation of their right to due process. There is nothing that is relegated of importance that precedes our membership's right according to the oaths that we all took of securing justice for the Lumbee people. And I will remind you, we were elected by people like these that are out here. And for us to really be grilling them about what we don't like, it doesn't matter what we don't like. We need to have a point of order, and we need to proceed and at least hear the concerns.
Okay. Mr. Wilford, can you do it in 40? No, I'm just joking with you.
I timed this thing, Mr. Chairman. I started out and it took me 2 hours, and I got it down to an hour and a half, and then I finally whittled it down till I got it between an hour and 15 minutes, and then I can't get it any narrower than that. For 16 times, a preponderance from 2005 to 2021, the tribal, we're talking about intent. We're talking about what the court said. They intended statutorily to empower the Board of Education to create and to put in place Section 3. If 6 times was a sufficient preponderance for the Supreme Court in Locklear v. Oxnard, then surely 16 times is sufficient in weight, in number, in importance, and preponderance for the Tribal Council to demonstrate its intentions that the Board of Elections promulgate, create election guidelines. It would be worthwhile for you to note this, what Section 3 of the Election Ordinance, Election Board Ordinance on May 4th, 2000 is titled. If you have that ordinance, that Section 3 is entitled Oath and Duties of Election Board. Their oath of office required them to promulgate the right rules. It reads in the second paragraph of page 3, section 3, the election board's authority. See what it is? The court is questioning the authority of the election board to write these rules. And you gave them that authority. And you've given it to them for 16 years. It reads this. It then lists 22 rules and regulations, but it goes on to say, but you're not limited to. So it's telling the Board of Election, You must write these 22, but if you need to write some more, write them. For the sanctity of our government, right? For the sanctity of all that we are, it was their duty and it was their responsibility to write election guidelines. And not for them to do it would have been a dereliction of duty and a violation of their oath of office, a breach of ethics. If the Supreme Court were as faithful to their oath of office as the BOE, we wouldn't be here tonight. It's not Ron Oxendine's fault we're here. It's not Wilfred Clark's fault we're here. It's Mark Brooks, Mary Beth Locklear, Joshua D. Malcolm, Everett Moore's fault we're here. It's their unethical behavior and the violation of their oath of office, the breaking of tribal laws that has us here. The very last sentence in the Ethics and Conflict of Interest Ordinance, and some of us are sitting under the sound of my voice right now, there is at least 8 people, including me, that helped write this thing. Sadly, I have to say to you, though, Mr. Chairman, there's 2 people in here that voted against it. Everybody in here didn't vote for this, didn't want no Ethics and Conflict of Interest Ordinance. The very last sentence in the Ethics and Conflict of Interest Ordinance describes the word ethics. Listen, it takes its meaning from the Black's Law Dictionary. It is the one and the only time our law is permitted to use any language of our tribal ordinances. It's the only time we're to rely on the definition of anything that falls outside of Lumbee custom. And it reads, ethics in this context is that contained in Black's Law Dictionary. Professionally right or befitting. Conforming to professional standards of conduct. The conduct of the Supreme Court in Locklear v. Oxendine's, it ain't right and it ain't fit, and it certainly doesn't conform to professional standards. If so, our government is in trouble. Somebody's already got angry about my preaching, so I'm not going to tell you about Nahum. I'll save that for another day. Right? You know, well, I'm going to leave that alone. The oath of office that the Board of Education election took requires that they create and put in place election guidelines. It is their oath and duties of the election board. They were told to do that. If they had not wrote those rules, it would have been a violation of enacted tribal law. It was their duty, and not to do so would have been a dereliction of their duty. It would have been a violation of their oath. It would have been a serious breach of ethics. My fervent hope is this ethics committee and this tribal council are as faithful to their oath and duties as the board is. Now, I'll try to get through this quick. We come to the Supreme Court's worst violation of our tribal laws. The gravest violation of their oath of office and their ethical sins that trouble me the most. I would never have imagined this would happen way back when I was slaving with 22 other people back in the 90s, week after week, month after month. This ain't left field. At UNCP, drafting our Constitution that was voted on and approved by tribal membership, I never would have believed that we would empower people to treat their own Lumbee people so inhumanely. So from our list of least common denominators, we use the word promulgate, intent, preponderance. Now here comes the word of all words that got his name off the ballot. I'd like to begin reading from the last paragraph of page 7 of the ruling in Locklear v. Oxendine. And this is what the Supreme Court wrote. In the October 13, 2021, 6 p.m. pre-hearing order, the court informed the parties that the court has considered in conference thoroughly the phrase principal place of residence contained in the Constitution of the Lumbee tribe. The court has considered in conference thoroughly the phrase shall be the will of the Lumbee people as expressed in the Lumbee Constitution, duly elected tribal ordinance, Lumbee custom, and in the absence of such, a governing rule of law shall be the governing rule of federal common law. The court has taken judicial notice, I hate that word, that there does not appear to be any constitutional provision ordinance, or prior court decisions establishing a definition of creating a rule of law concerning or related to a principal place of residence. Did you hear what it said? The court has taken notice that there does not appear to be any constitutional provision, ordinance, or prior court decision establishing or creating a rule of law concerning or related to principal place of residence. The court could not be more wrong. Not wrong because they don't know any better, because they do, but because they're wrong, because it won't help them get Ron Oxendine's name off the ballot. Listen, there is no requirement in the Constitution. There is no requirement in any tribal ordinance. There's no requirement in any Lumbee custom that a court has to define every word that it takes judicial notice to define. Everybody in this building knows what the rule of law. They don't have the right to tell us what we think. That's what Lumbee custom was put in the rule of law for. The rule of law is what the preponderance of us say it is. It's what the people in Prospect says, and every other tribal territory is. We know what the rule of law means, and we know what principal residence is. The Supreme Court doesn't need to tell us. We're grown. We're not youngins. You just can't take a willy-nilly judicial notice and change the words that we have used all our lives. You wouldn't be using it now if you weren't so determined to get Ron Oxendine's name off the ballot. They're obsessed, they're blinded, they're desperate, and they can't stoop too low to do this. We say this, why don't you just confess? Most of us in this building profess to be Christians. We'll forgive you, right? We'll pray you through it. That's the Lumbee custom at its finest. All we are, Brother Burnett, in our custom was rooted and grounded in the basis of the scriptures that sustained us for 300 years. The Bible was our community. The Bible was our rule of law. The Bible is what made us. Our yea ought to be yea, and our nay ought to be nay. And we'll forgive you. Ethics, professionally right and befitting, conforming to professional standards of conduct. The actions of the court on this Supreme Court has not been professionally right. They've been criminally wrong. They aren't befitting the honor, title, and position they hold. They haven't held themselves to any professional standards of conduct in administering justice fairly and impartially. They couldn't do that. Regarding the Lumbee part of the Constitution rule of law, I'm going to read for you, and I'm sure you've seen it now. If you hadn't got a copy in the mail on email, you've probably seen it on Facebook or somewhere. I want to read you a part of a dismissal petition from the administrative court in Ron Oxendine and Wilfred Clark versus the Supreme Court. This is what the administrative court said in reference to your Supreme Court. Based upon Tribal Ordinance 2005, along with Lumbee custom, that the election board has traditionally dealt with controversy surrounding tribal elections, this court is of the opinion that the Supreme Court has erred to resort to federal common law when the Lumbee tribal constitution states what the rule of law is in there. Lumbee custom, it says, has already been established prior to this case. This court also questions the legitimacy of the Supreme Court to qualify a complaint coming into an ongoing election so far into process. It must be stated that the host of email sent by the Supreme Court has been interpreted by the administrative court. Have you read this? It must be stated that the host of emails sent by the Supreme Court has been interpreted by the administrative court as a means of threatening this court into compliance. How unethical can you get? We shouldn't be here, but I got a feeling that it ain't going to be long before you cut me off, so I better get this while I can. We don't have any business to be here. We wouldn't be here. The closest thing that we have in our Constitution that's an equal justice under the law for all of them is contained in our preamble. Right. That's the closest thing we got. I'm looking at the Supreme Court of the Lumbee Tribe a dismissal order from 2013. Johnny Chavis petitioner versus Carvecus Barfield, election board chairperson, is the respondent. This is a petition that went before the Supreme Court. This is why we ain't even got no business being here. Right? Petitioner filed an appeal to the election board decision on December the 6th, 2013. Right? Petitioner was notified that the election that he called into question has been certified on or before November the 20th, 2013, prior to the date of the filing of this petition. And I've lost my note. I'm sorry. Bear with me just a minute. This order was signed by Gary L. Locklear, Chief Justice of the Supreme Court. This is the ruling of the Supreme Court regarding filing petitions once the period to contest it is passed. Lumbee custom and precedent was established by Gary L. Locklear, right? Chief Justice of the Supreme Court of the Lumbee Tribe. And this is Mr. Locklear's words. From the foregoing facts, the court concludes as a matter of law, without addressing the merits, whether it's a good case, whether it's a bad case, whether you got a good complaint, whether you can call them guilty or not. Judge Locklear said it makes no difference. He says that this petition was not filed in a timely manner. Mr. Chavis filed this petition 16 days after his right to file a petition had ended. You remember that, don't you, Ms. Barfield? It is therefore ordered that this petition be dismissed without further hearing from the court. The judge said, the counsel for the petitioner in this fiasco, the judge, Gary Locklear, said, it don't make no difference if you had a good case or if you had a bad case. The statute of limitations had run out and you can't file it. 16 days. 16 days. Here comes David Locklear. And he files a petition in the Supreme Court, and he uses for his lawyer, this judge that said that, Shelley Strickland. David Locklear filed this petition 21 days past his right to file the case. If the court would have followed precedent, if it would have followed established common law or Lumbee custom, when the Supreme Court, when Malcolm and Brooks and Locklear and Moore got this, they just said, no, you may have a point there, Mr. Locklear, but you didn't file it in a timely manner. Mr. Chavis was 16 days late. And according to the court, that was not a timely manner. If 16 days ain't a timely manner, how does David Locklear get 21 days and be on time?
26.
Help me out. Beam me up, somebody. It should have never. If the Supreme Court would have followed tribal law, we would not be here. Don't get mad at us because we're fighting for our rights and the right of another 65,000 people. Because the next time, it may be Locklear v. McNeil. It may be Locklear v. Hunt. It may be Locklear v. Moore. It may be Locklear v. Goolsby. It may be Locklear v. Strickland. It may be Locklear v. Jones. Can I ask you this? If you were Ron Oxendine and they violated your constitutional right after you had spent tens of thousands of dollars, would you be mad? If you got the sense, you would. So, Mr. Chairman, we wouldn't be here if the courts hadn't broken the law. Breaking the law is a violation of their oath. Breaking the law is a serious breach of ethics. It does not conform to any standards of professional conduct. It is not befitting the honor they have. They're the reason we're here. Don't get mad at us because we're fighting for our rights, right? They knew that. They knew that. And let me quickly, then I can wind it up real quick. I can do it fast. If you ain't heard enough by now, you ain't heard enough to begin with. So they come to us, so they've got to make this case for residency. That's what got his name off. So they got to find some federal, they've already overlooked the Constitution, the Ordinance, and the Lumbee Custom. So they look now to federal common law. So they look, boy, they must have spent a whole lot of time doing this. And they dig up a case, a federal common law case, right, decided by a court in Louisiana, the Fifth Circuit Court of Appeals, Ackridge v. Evangelical Lutheran Good Samaritan Society. Mary and Louis Ackridge. And they're questioning their residency, Mr. Chairman. So what is this case they got? Louis Ackridge was born in Colorado. He moved to Clovis, New Mexico in 1968. And he went to work as a deputy sheriff in Clovis, New Mexico. And in the process of time, he got dementia, Alzheimer's, and he began to lose his mind. He couldn't take care of himself, Shelley. So his wife put him in a rest home in Clovis, New Mexico. After about a year in that rest home, she noticed, boy, they're not treating my husband good. I got to get him out of here. So she takes her husband, and he don't know if he's in China or Australia. She takes her husband and finds a rest home across the straight line in a town called Farwell, Texas. And she puts him in a rest home that's owned by this corporation there. By the way, this corporation is headquartered in North Dakota. Within a matter of time, Mr. Lewis has a new roommate, a man named Henry Plyer. Henry Plyer has a reputation of abusive behavior to other patients. One day, the staff of the rest home there in Farwell, Texas, they went into the room and they found Mr. Louis Ackridge had been beaten to the point of near death with a coffee pot by a man named Henry Plyer. Mr. Plyer was not satisfied. He took a ballpoint pen. It's in there. You ought to read it. This is what they use now. We didn't bring this. This is not Ron Oxendine evidence. This is your Supreme Court's evidence. He stabbed Louis Ackridge in the eye socket with a ballpoint pen. And when they found him, the ballpoint pen was sticking out of his eye. Louis Ackridge died 8 hours later. In the process of time, his wife, Mary, she wants to settle the estate. She files a suit, a negligence suit against these people, trying to get damages. Lawyers got in it. Boy, lawyers can really mess things up. We ought to kick them out of the building. We ought not let it. You got a law degree, you ought not be able to come in here unless we blindfold you and mooch you, because you'll just create problems. They always do. And I can prove it to you in this courthouse and every other courthouse. So now they're settling. She's trying to probate her husband's estate. So this question of residency comes up. Do they live in Texas or they live in New Mexico? Who settles this? Backwards and forwards, the appeals went. Finally, when they couldn't get no further, they went to the common law court. They went to the common law court, and the court resolved the issue. I'm going to quit. I don't need to go no further because some of you ain't listening and you're getting ill, and I don't want to make you ill because we need 11 votes. That's what we need. So the issue of residency comes up. So they go to the federal court, the Fifth Circuit Court of Appeals, and in the ruling that they got, that they hoped that you would never read, but I read it. I've been reading it for 3 weeks. This is what the common law court says regarding residency. It says residency is an ambiguous word whose meaning in a legal phrase must be determined in each case. Okay? I'm going to quit. I'm tired anyway. The word residence, it says, has many meanings. This is their evidence now in the law, and it's largely determined by the statutory context in which it is used. So we have the Supreme Court using residency laws in the state of Texas and the state of New Mexico to solve a residency issue about a poor old widow as to what state she lives in, where you can get that rest home to pay her, right? And settle his estate. And that's the case, Louis Ackridge v. Lutheran Evangelical Society. That's the case that the Supreme Court brings to you to establish the residency of Ron Oxendine to run for tribal chairman in North Carolina. I could go ahead and read on you, but I'm going to summarize it to you. If you don't, you get it yourself and you read it, right? If you want to. Read that fairy tale if you want to. So here's the point. Within this thing it says this, right? The federal common law always looks to the state court. See, what is the state law? What is the state law concerning this? What are we dealing with here? Now, when they tried to settle with this woman, they didn't look at the state law in Minnesota. They didn't look at the state law in California. They didn't look at the state law in Arkansas. They looked at the state law where the suit originated. We are the Lumbee tribe of North Carolina. We are not the Lumbee tribe of Texas. We're not the Lumbee tribe of New Mexico. What in the world is that residency law got to do with us? And the answer is, it's nothing. But that's what they done to get his name off the ballot. That's what they done to do that. But we're here. So the question is this, and I may get in trouble with you again. It's hard for me to keep from calling them words, and I'm a good Christian man. I know that I am who I'm saved by the blood of Jesus, but I'll tell you what, I'm a human being too. Them people are rotten. They're rotten. They'll lie and say anything to get their way. They'll do. So you have to ask yourself this question. If we're going to use federal common law to determine the eligibility of Ron Oxendine to run for tribal chairman in North Carolina, why wouldn't they use North Carolina common law cases to do it? Why would they not do that? I know why. Because they couldn't get his name off the ballot. If you would call a 5-minute recess right now, and everybody that's under the sound of my voice, go into your smartphones, iPhones, and key these words in to Google search. Federal common law residency requirements for the state of North Carolina. If they would have done that, they could have, 6 of them would have popped up just like that. 6 of them would have popped up just like that. They could have used either one of these 6 federal common law cases, right, to establish the residence of Ron Oxendine of the Lumbee tribe of North Carolina, not the Lumbee tribe of Texas, and New Mexico or no other state of the United States. But they didn't. See, North Carolina, let me say this. In their ruling, in their acries, it says this, within the statutory context, see, there are different residency laws to get in-state tuition. Right? There's a different residency law, right, to get Medicaid. There's different residency laws to make you eligible to vote somewhere. And there are different residency laws that allows you to file in court or file for political office. Ron Oxendine filed an office for a political question. Why would they look at residency requirements as it relates to the eligibility to file for political office? Well, it wouldn't get his name off the ballot. It wouldn't get his name off the ballot. They went all the way back to 2003's resolution of a case of a man that was killed in 1999. And if you'll pull out that thing right there, you will find 2 North Carolina common law residency cases that were settled 28 months ago in June of 2017. Why didn't they use them? They couldn't get his name off the ballot. And the basic residency statute, pull it up on your Google, is this. To establish residency in the state of North Carolina, a man or an individual must live in the tax year a minimum of 183 days. If he does that, he establishes residency. Why 183 days? Well, there's 365 days in the year. 183 days represents 6 months and 1 day, a majority. That's the basis of residency law in North Carolina. Why they couldn't do that? And I'm going to end by saying this. They should have, and they know that. Them fellas, they passed 3 of them fellas passed the North Carolina Bar Association. I'm a little nappy-headed boy born in Fairmount with a 12th grade education from Magnolia, and I figured this out. I figured it out. They didn't think nobody would figure it out. They must have forgot I ain't got nothing to do all day. I sat around all day reading the Bible and reading this, and I figured it out. And let me show you why they could for political office, which what federal court says his residence should have been determined on. Let me remind you 2 different women. You ever heard of Hillary Clinton? This ain't left field, right field, center field. It ain't even dug out the bleachers. I'm on the pitching mound right now. That's where I'm at. Hillary Clinton was from Arkansas. And she was married to a man named Bill Clinton. They got elected president of the United States, and they moved to Washington, D.C. Bill Clinton's term is about up, and all of a sudden there's a Senate seat up for grabs in New York. Hillary Clinton never lived in New York. So what does she do? She shoots up in New York, gets her an address, sticks her a mailbox post down in the ground, and she establishes a residence. And immediately, under residency laws, as a regard for filing for a political office, she was qualified to run. And she did. And she won. She didn't qualify herself to run on Texas law, residency law, which is what that is. Not New Mexico law, not even Arkansas law, where she lived at. But she qualified to run for political office on cases in the law of that state. She ain't the only one. I remember when she done that, a lot of Republicans got mad. They had to eat crow the next year. You know why? Because here's a woman named Elizabeth Dole. She was born in North Carolina. Her husband's Robert Dole. They live in Kansas. And he's a United States Senator. And they moved to Washington, D.C. He's going to retire. He's getting so old. There comes another Senate seat up for grabs in North Carolina. She shoots back down here to North Carolina, sticks her mailbox post down in the ground, and instantly she's qualified to run for a political office. And she did. And she won. She didn't qualify for residency to run for a political office in North Carolina on Texas law, on New Mexico law, not North Dakota law, not New York law, but they done it on North Carolina law. I could go for another 2 hours and show you 25 different places in this thing where they lied, connived, deceived, and tricked you just so they could get his name off the ballot. They did it. They did it. They're rotten. I'm not going to call them dunces or nothing like that. I ain't not going to call them no bad words. Let me close by saying this. Let me close. I'm done because I'm tired. I'm getting thirsty and nobody won't get nothing to drink. Here's the point. Here's the point in all of this. Everybody thinks the Lumbee tribal government is corrupt. You know that, and I know it. And they do. And sadly, Mr. Chairman, we have given them a multitude of reasons to feel that way. And now we've got obvious ethical issues with our Supreme Court. They insulted you. If you ain't seen it, every one of y'all ought to be walking around protesting. Give me that letter that Mr. Burnett's got. I like to flag it and wave it around. It looks good. That's the letter that, I don't know if Mr. Burnett has given that a copy of that there. This is the tribe. This is what they got. If you, in the last page, all that other stuff was baloney. They got to talking about their authority under tribal law and out in the Indian world. I don't care what the Apaches are doing. I don't care what the Seminoles are doing. I don't care what the Choctaws are doing. Do you? I care about what we doing. We can't run our government based upon how the Utes and the Pilots and the Pequots, we can't do that. We've got a constitution. We've got law. So in that, they say to you, and this is the bottom line, if this don't make you mad, you ain't got an ounce of mad in you, except maybe for me. Accordingly, the court, just as it did in 2019, hereby declines, look at the word they use, to subject itself. Ain't that pompous? Ain't that obnoxious? Ain't that arrogant? Ain't that a man lifting himself up in pride, that he would have to subject himself to the jurisdiction of the Ethics Committee? You know what he's saying? I know the Ethics Committee applies to me as an appointee, but I don't care what the ethics rules are. I don't care what the Ethics Committee says. You can get mad at me shouting if you want to. That's part of custom to you. That's what they're saying to you. I do not care what you think. But we do have jurisdictional authority over them. I got so mad I went back and I searched back Alexander Hamilton, one of the statesmen of our, one of the founding fathers, and he talked about obnoxious executives and government officials, that we must have a mechanism in place to get rid of that crowd. We've got the mechanism in that place to get rid of that crowd, and it's called the Ethics and the Constitutional Interest Ordinance. Ricky Burnett, you voted for it. You did it. Shelley Strickland, you voted for it. Right? Wendy Moore Graham voted for that thing. Pam Spalding voted for that thing. She did. Sharon Hunt voted for it. I voted for it. Gerald Gooseby voted against it, too. Even John Lowry voted against it too. But they had the reasons. I'm not saying nothing bad. They had the reason. But we have got it in place to do that. And we got to get rid of that crowd because they are repeat offenders. They've done it before and they'll do it again. I'm done right now. You are the conscience of this government. Give me 3 minutes. Give me 3 minutes. I began this presentation with a man named Vincent Lowry. I want to end it, and y'all know him, a lot of them. I want to end my presentation to you by introducing to you a woman named Doris Williams. You probably never heard of her. Doris Williams goes to East Lumberton Free Will Baptist Church, one of my conference churches over here. Doris Williams sings the song, and most of you Christians probably have heard it. And the name of that song is What's Wrong with Doing Right? What's wrong with doing right? If you want to change the direction of this government, the eyes of the tribal membership, it's off the Supreme Court now. It's on y'all. It's you now. It's you now. They're going to see, and the question that they're going to ask you is what's wrong with doing right? We must, and until we start holding people accountable for bad behavior, it's going to get worse, and it's going to get worse, and it's going to get worse. Stop it. I am begging you. We need 11 votes. That's what it says in the ethics and conflict of it. 11 of you. 11 of you. And understand this. See, one of them 4 Supreme Court justices may be innocent. I was hoping that they'd have a battle of their conscience and get up here and confess and tell us it's wrong, but they didn't. But which one of that 4 is, we don't know. But your vote will be recorded. And people are going to know if you have something wrong with doing right. You're going to give an account of it. And I'm not threatening you. I'm just saying. You cannot hide. You can go into executive session all day, but you cannot hide from the vote that's going to be printed as to how you vote to get rid of these people. Thank you.
Thank you, sir.
Mr. Chairman.
I'll entertain a motion that we go into closed session.
Mr. Chairman. Mr. Chairman.
Oh, I'm sorry.
Yeah. Let me just follow up and close. And I want to read again. According to basic North Carolina instructions, a North Carolina resident is an individual who is domiciled in North Carolina at any time during the tax year. If you resided in the state for more than 183 days during that tax year, you will be considered a resident. I filed my North Carolina taxes in 2021. I've been here longer than 183 days, over a year. But yet I was disqualified because of residency in Locklear versus Oxendine. It is an injustice, not just to me, but to our Lumbee tribe and everybody who wanted to go vote and express their right to pick their chairman. If you don't give me the right to have the opportunity for our people to choose me, whether they do or not, it doesn't matter. The point is they need to have that opportunity. The only way that can be done is Locklear versus Oxendine needs to be reversed or terminated or whatever that proper term is. I don't know. I'm not a lawyer. But if we don't give our people that right, you'll end up with 4,000 people like you did on 9 November. That election needs to not be certified. I certainly, and I think a lot of other people that's on this Zoom, believe the same thing. And it's important that this ethics committee and tribal council create a new election. Do it by 25 December, before Christmas. Give that responsibility to the Board of Elections. They'll pull it off. And then results of that election will determine who the chairman is. I want to thank you for your time, but I believe that what we've shown you in the last 2 hours, or close to that, hour and 45 minutes, provides the evidence that it's clear the Supreme Court believes they can use the Constitution when they want, how they want. They don't have to listen to or report to anyone. And so they make up law to accomplish the goal of getting Ron Oxendine off the 9 November election. That was the sole purpose of that event. And they did it. But if you can see the evidence that we provided tonight, it was wrong. And they broke their ethics and conflicts of interest. And it's upon you, it's your responsibility to fix this and make those changes. Thank you for the opportunity. I appreciate your time tonight. Yeah, I'm sorry. Excuse me.
Mr. Chairman, to answer Mr. Goolsby's question, he is going to give to you a copy of my whole narrative and whole presentation. Right? He's going to give it to you, and you can read it and you can study it, and you can do it all without all my loud voice in the peace and solitude of your house. But if you can read it, if you'll read it and heed it, the Board of Elections will be cranking up again real quick.
Mr. Speaker, I offer a motion to go into closed session.
I have a discussion.
Motion and second.
I'm sorry.
Let us go into closed session. Back in the back. Praise God. Praise God. Everybody. Make a motion out of closed session.
I'll make a motion that we come out of closed session.
I second.
Moved in second. All right. Let me say we thank you again, Mr. Oxenine, for coming. And we've been back there and we've been talking, going on. But what we did, we have not come up with a decision yet. What we're doing is we want to request within 5 days that letter that you were talking about was not in from the North Carolina bar that Mr. Malcolm had said. Going to send him a letter requested we get that letter back in 5 days, and then also to review the hearing again, the early part of it, and then we'll come together and make a recommendation. Then it'll go to the full council. But at that same time, I definitely will inform you and let you know when that's going to take and be.
Okay.
Okay.
Thank you.
Have a motion to adjourn. Second. All in favor? If you'd stand. Preacher Harold, would you dismiss us?
We thank you as we come together. I often think about we didn't ask for material, we didn't ask for gold, we didn't ask for good, we asked for God. Anything that the council, administration needs, our government, we need God. We need to be a house outside. Heavenly Father, Lord, we pray for your wisdom, your leadership, and your guidance. We thank you that you're God. We thank you, dear Heavenly Father, that in spite of our shortcomings, for the Bible says that yet while we were sinners, Christ died for the ungodly. Dear Heavenly Father, we thank you that you sent your Son to die for us. We thank you for your love, your grace, and your mercy. Dear Heavenly Father, Lord, we are Lumbee people. We were born and raised on the Bible. We believe God. We believe His word. Dear Heavenly Father, it's my prayer that we would come together. In the midst of all of this, we would come together and be stronger as Lumbee people as we do what's best for all of our people. We thank you. We love you. Dear Heavenly Father, I pray as we go our separate ways, wrap your loving arms around us and keep us safe and in your precious hand till we come this way again. We thank you. We love you. And in your name I do pray. Amen.
Amen.
Mr. Hurl.
Mr. Ron.